Hi, my name is David Ruben of the Ruben Law Firm. Today what I want to do is try to give you, if you're coming to my website looking for information about family law, child support specifically, an illustration of what the Maryland Child Support Guidelines looks like. People call lawyers all the time and ask them questions about guidelines. People represent themselves and go into courtrooms, and the lawyers and the judges are like, yeah, it's the guidelines. This is what the guidelines are. This is what you have to do. Well, first of all, guidelines is kind of misleading because it's not really guidelines. Essentially, it's mandatory. But people who aren't in this profession or don't have access to this software really don't know what that means. So the goal here is to show you, whether you hire an attorney like me to help you out, whether you do this on your own, whether you're helping out a friend, knowing what the Maryland Guidelines Worksheet, Child Support Guideline Worksheet looks like can be a big advantage to you, so you're not taken aback when you go to court and you have a good understanding of what it is. So let me turn to you. I'm here in my office on my computer with what's called Sassy Calc. Sounds weird, no need to explain why it's called that, but it is the child support calculator that at this time in October of 2021, and it's been this way for many, many years, literally every family law attorney who does a lot of family law work and every judge and magistrate has this program on their computer, and they refer to it both out of court and in court. A lot of times toward the end of the trial, you'll see a judge pulling up computer software on his computer or her computer, and they'll be doing the guidelines. It would be beneficial for you to know what that looks like, so I'm going to show that to you now. So this is what we call the Maryland Child Support Guidelines Worksheet on the computer program called Sassy Calc Professional. And like I said, this is the program that all of the judges and magistrates who handle child support cases have, and most of the family law attorneys in the state of Maryland have. And you're welcome to call our office anytime and we can run numbers for you if you don't have it at home. I will say though, if you Google Maryland Child Support Guidelines, you may be able to find something online that is provided through the state where you don't have to pay for it and you can run the guidelines there. But this is the calculator that we have found to be the most accurate and is used by the judges, and of course that's what matters. So in this program, this is the form that's going to come up. You're going to put the case number. Now you don't need to put a case number right now. Only when that's submitted to a judge you need to put a case number. Right now, for purposes of figuring out what your child support obligation in Maryland would be, you don't need that. It does not matter what county it's in. It's the same for every county in Maryland. Plaintiff's name, we're going to put mother for now. Defendant's name, we're going to put father. Children's name, I just put one child. If there are 2 children, you put the other child's name, or 3 children. It calculates it all the way up to 6 children. You're going to put that child's date of birth. I put 10. It doesn't really matter what the child's date of birth is or how old the child is, as long as the child is under the age of 18 at the time you're doing the child support guidelines, or if over the age of 18 has not yet graduated high school. That's a separate issue. Custody type. Now, this is where we get into litigation. This is what gets important. We've got sole mother. What does that mean? That means that the child is primarily with the mother. Recently, these guidelines changed. We used to have a number of 128 if the father or the non-custodial parent had more than 128 overnights. It used to be what we called shared physical custody for purposes of calculating these guidelines. It's now 92 overnights. Those laws went into effect about a year ago. So 92 overnights. We don't have sole mother. We have what we call shared, parent 1 and parent 2. So we can have either sole mother, we can have sole father, sole mother if the child's or children are primarily with one parent, not more than 92 overnights, or we can have shared. And that would be anywhere in between one parent has somewhere more than 92 overnights and less than a certain amount. And you'll put those numbers in here. As I move down here, it says number of overnights. 273 overnights with one parent, 92 for the other. If it was true 50-50, it would be 183 overnights with one parent, 182 nights with the other. So you put in how many overnights, and depending on that, the amount of child support that the non-custodial parent is going to pay is going to fluctuate. And the only way you can know exactly how this algorithm works is to put in the exact numbers, because a change in a certain amount of overnights may be a big change, it may not be a big change. It's not a perfect system. We just put in the numbers, and as we say, it is what it is. So the important numbers are monthly income. How much money does parent one make? Let's say parent one is the mom, and mom makes $48,000 a year. We put in $4,000. Now, when do we litigate these cases? I mean, the reason for the guidelines is to reduce litigation, to have some kind of basis for how much child support is going to pay. Because before these guidelines were enacted, every case was a child support issue. One parent would say, the child doesn't need this, the child doesn't need this, I'm giving plenty of money, I'm paying this. Every single case was litigated about every single expense and need for the children, and other states developed these child support guidelines, and Maryland followed about 25, 30 years ago. And it's been a good thing for the most part. It's very frustrating for people sometimes because it's so strict, but if you don't realize how much litigation it avoids, it's a good thing. But how do we litigate? Well, mom says she makes $4,000 a month. Well, dad could say, well, no, she doesn't. She makes $60,000 a month, or she has the ability to make $60,000 a month. So we put that number in. Sometimes we fight about that, sometimes we don't. But if we know the numbers, and usually with W-2 employers we do, we can calculate guidelines pretty easily. Or we can estimate what we think somebody makes. Dad is self-employed. Dad's tax returns say he makes $32,000, but dad really makes $100,000. Well, then you're going to have a judge decide how much he makes. But if we can agree on how much he makes, let's say dad makes $4,000 a month as well. We also put in, is there an existing child support payment for a payment? Now that would be a child support for one of the parents that they had before this child support is ordered, and that number would go in here. So let's say mom has a child from a previous marriage, and that child is living with that father, and she's paying $200 a month in child support already pursuant to a court order. We would put that number in there. That's where that goes. Usually that's not the case. Now, a lot of people ask the question, what happens if they have new children after the separation? They go on to another relationship. Does that get included in that calculation guideline? And the answer is no. It is something to consider, but we don't put that number in there. Then we have alimony. If in this case, or in this case, a judge has awarded alimony and parent one is receiving alimony, we put that number in here. If parent one is paying alimony, we put that number in here because it's increasing one parent's income and it's decreasing the other parent's income. We have overnights here. A lot of times we can't calculate child support until custody is resolved because mom wants primary physical custody and dad wants primary physical custody. So we can't even do the guidelines until at the end of the trial the judge says, this is what the access schedule is going to be. Now we put the numbers in for child support. But sometimes we've already agreed on custody, 50-50, 183, 182, or some other arrangement, whatever that might be. And then it's up to the court to determine what the actual incomes are. But if you agree on the amount of overnights and you agree on these numbers, there is no argument regarding child support. As we say, it is what it is. We put health insurance payments. One parent pays for health insurance for the children. How much do they pay for health insurance? We always tell our clients, you're going to have to go to your employer, you're going to have to figure out how much it costs for you and the kids and how much it would be if it was just you alone. Do the difference. That's the number we use for health insurance payments. We usually don't fight about that. It's pretty easy to figure out. Extraordinary medical expenses. This comes up sometimes. Is one of the children in therapy? Is one of the children need braces? Are these ongoing regular expenses that we're going to have to do? We put those numbers in here. Cash medical support is something that is new that we're including in the guidelines. Additional expenses. Now, this can be interpreted as well. There's additional expenses. That can be anything. It can be lacrosse practice. It can be swimming lessons. It can be this or that. It can be clothing. It's not. Additional expenses is going to be very narrow to specific purposes and cases. And it's a case-by-case basis. But if you talk to a lawyer and you say, well, what about this that I'm paying for? No, they're not going to count that. Oh, yeah, they're going to count that. Tutoring, whatever it might be. And at the end of the day, you're going to come out with a number. So for example, in this scenario, I've got monthly income for mom, $4,000, monthly income for dad, $4,000. Mom's paying child support for another child of $200. Their overnights are equal. One parent has to pay the other $25 a month in child support. Now, that it's just a completely example, but this is how this process works. And the minimum for a family is $30,000 of gross monthly income to do these guidelines, meaning the maximum, not the minimum. So anywhere up to $30,000, the court's going to take this guideline as a presumption. That's going to be the number. To the extent that you're making more than that, which is gross household income of more than $360,000 a year, the court has more discretion. The court also has more discretion if it's a shared physical custody scenario. But I think at least it is good for you as a potential client, as a potential litigant, somebody going through litigation, somebody that already has a court order that's now looking back to say, hey, I lost my job, I'm making more money, the child's not in daycare anymore. I think I actually skipped over work-related daycare. Work-related daycare goes in there as well. And usually that number is easy to determine, but people fight about it. Hey, the kid's grandma is watching him. She shouldn't have to pay that person money. That's all fake. So, we try to resolve all these issues with the guidelines so we don't fight about child support, but we often end up doing that in court. But hopefully you having at least the understanding of how this process works will give you a better idea of how it's going to work when you ultimately get to court and an attorney. As always, if you have any questions about this, or you have a child support case ongoing, and if you have questions, feel free to give us a call, or if you're looking for representation, of course, we would be happy to do that. Thank you.